Yeah, I think you can hear me now. Everything is looking well. Okay, okay. So please tell me कि क्या हमने माइनर में कुछ भी लिखा था? प्लीज टेल मी. मैंने माइनर के आपको सारे एलिमेंट्स बता दिए हैं. आज जब लिखेंगे तो सब कुछ रिवाइज भी हो जाएगा. जस्ट टेल मी, हैव यू रिटन एनीथिंग इन माइनर एज येट? आई होप आप सबने माइनर की क्लास अटेंड कर रखी है, बिकॉज टुडे आई एम गोइंग टू डिक्टेट एवरीथिंग ऑन माइनर. सो फॉर दैट इट्स इम्पॉर्टेंट दैट यू हैड अटेंडेड दोज क्लासेस, और आज की क्लास से आपका सब कुछ पॉलिश हो जाएगा. नो, वी हैड नॉट रिटन एनीथिंग. ओके, सो लेट अस बिगिन. लिखो फर्स्ट. हम कॉम्पिटेंसी पढ़ रहे थे जिसकी 3 कंडीशंस होती हैं: एज ऑफ मेजॉरिटी, साउंड माइंड एंड नॉट डिस्क्वालिफाइड. राइट, ठीक है. तो फर्स्ट पॉइंट, who is a minor? Person below 18 years as per the Majority Act 1875. मैंने आपको दिखाया भी था. आई एम अज्यूमिंग कि आपको सब कुछ आपने पढ़ रखा है. आज आप सिर्फ लिख रहे हो. In a very systematic fashion we'll write. So who is a minor? Person below 18 years as per the Majority Act. Section 11 में ये दे रखा है, every person is competent to contract who is of majority according to law to which he is subject. If we open the contract का bare act, तो who are competent to contract? Every person is competent to contract who is of age of majority according to the law to which he is subject. So we are subject to Majority Act. उसके हिसाब से who is major? Who has attained 18 years. ठीक है. Our second point. Section 11. इसको 2 पार्ट्स में डिवाइड करो. फर्स्ट में लिखो, it declares that minor is incompetent to contract. ये तो सेक्शन 11 बताता है कि माइनर इज इनकॉम्पिटेंट, क्योंकि 11 इज सेइंग एवरी पर्सन इज कॉम्पिटेंट हु इज ऑफ एज ऑफ मेजॉरिटी. तो कॉम्पिटेंट है जो एज ऑफ मेजॉरिटी का है, इज इक्वल टू जो एज ऑफ मेजॉरिटी का नहीं है, जो माइनर है वो इनकॉम्पिटेंट है. ये तो बताता है 11. तो स्टफ लिखो, इट इज साइलेंट अपॉन nature of agreement entered into by minor. ये तो बताता है 11 कि माइनर इनकॉम्पिटेंट है, बट माइनर के साथ जो ट्रांजैक्शन होगी वो वॉइड होगी या वॉइडेबल होगी, इस पे साइलेंट है सेक्शन 11. इसके बारे में कोई गाइडेंस नहीं है. वैलिड तो हो नहीं सकता क्योंकि कॉम्पिटेंसी की कंडीशन नहीं पूरी हो रही, बट बचा वॉइड या वॉइडेबल, इसके बारे में वो साइलेंट है. ठीक है, इसके नीचे लिखो, हेंस द पोजीशन हैज बीन deduced from case laws. क्योंकि स्टैट्यूटरी लॉ में गाइडेंस नहीं है, तो हमें केस क्लॉज से अपना लेना पड़ेगा, क्या बोलते हैं, से हमें लेना पड़ेगा गाइडेंस। ठीक है, ये सब कुछ मैं पढ़ा चुकी हूँ, मैं सिर्फ लिखवा रही हूँ। आई होप एवरीबडी इज गुड। ओके, थर्ड पॉइंट, नेचर ऑफ माइनर्स अग्रीमेंट। इसको 2 में डिवाइड करना। Earlier position, present position. ठीक है, earlier position में लिखो contract entered into by minor was deemed to be a voidable contract. Contract entered into by minor was deemed to be voidable contract dash at the option of minor. At the option of minor. At the option of minor. तो पहले voidable होता था और माइनर के पास ऑप्शन होता था कंटिन्यू करना है या सेट असाइड करना है। ठीक है, उसके नीचे आरो बना के रखो। This was governed by English law. This was governed by English law. Okay, दूसरा लिखो now an agreement with minor is void ab initio. An agreement with minor is void ab initio. Dash, it has no standing in the eyes of law. It has no standing in the eyes of law. उसके नीचे आरो बना के लिखो this was declared in the case of Mori Bibi versus Dharmodas Bose. Mori Bibi versus Dharmodas Bose. ठीक है, ये हो गया आपका नेचर्स ऑफ माइनर अग्रीमेंट। अब आ जाओ फोर्थ, Mori Bibi versus Dharmodas Bose, 1903 Privy Council. This is the most important case on the topic of minor, and we'll write down the facts also. ठीक है, देखो। मैं आपको ऐसे लिखवा रही हूँ कि कल को आपको एकदम से याद आ जाएगा. So Dharmadas Ghosh is a miner. He owned an immovable property, and Brahmodat is a moneylender. But he was mostly away on business, and his work was managed by his agent Kedarnath Mittal. Requested loan of 20,000 on security of house, and Kedarnath Mittal informed him that I'll let you know. This is not Bose. This is sorry Bose. ठीक है. पहले इतना लिखो, ये सब मैंने आपको बता रखा है, सब कुछ। Everybody is good? Please tell me एक बार, online students, are you good till here? Then we'll proceed. एक बार बताओ, are you good till here? Okay. या अब लिखो इसके आगे, ओरिजिनल केस धर्मोदास घोष ने फाइल किया था ब्रह्मोदत्त के अगेंस्ट। ओके, वेयर कैलकाटा सिविल कोर्ट, relief claimed, cancellation of mortgage, ground, minority of plaintiff। ओरिजिनली धर्मोदास घोष ने ब्रह्मोदत्त पे केस फाइल किया था अपनी मॉर्गेज की कैंसिलेशन के लिए ऑन दिस ग्राउंड दैट ही वाज अ माइनर। ठीक है, धर्मोदास had sued Brahmodatt, he won and Brahmodatt lost। फैसला आया था, धर्मोदास जीता था, ब्रह्मोदत्त लॉस्ट। देन Brahmodatt filed first appeal against Dharmodas in Calcutta High Court। He lost, Dharmodas won। Finally, Brahmodatt filed second appeal against Dharmodas in before Privy Council। By this time, he died and case was बाय दिस टाइम नहीं होगा, लेटर होगा, लेटर ही डाइड, बाय दिस टाइम नहीं, लेटर ही डाइड and the case was continued by his legal representatives, LRs, including Mohri Bibi. And finally, they lost and Dharmodas won. तभी केस का नाम है मोहरी बीबी वर्सेस धर्मोदास बोस। पता है ये क्वेश्चन एग्जाम में इतनी बार आया हुआ है कि ओरिजिनल प्लेंटिफ का नाम, ओरिजिनल डिफेंडेंट कौन था। इट वाज नॉट मोहरी बीबी, ओरिजिनल डिफेंडेंट वाज ब्रह्मोदत्त। या मोहरी बीबी किसकी वो थी, लीगल एयर, ये भी क्वेश्चन आया हुआ है। लॉस्ट। ये फैक्ट्स हैं, पूरे केस के, और प्लीज जो ली थी वो मैं भी आपको लिखवाऊंगी। तो दीज आर द फाइनल फैक्ट्स। ठीक है, अब इसमें सब हेडिंग लिखो। दिस इज नॉट द नेक्स्ट पॉइंट, ये आपका थर्ड पॉइंट है ना। थर्ड पॉइंट है ना, नहीं फोर्थ पॉइंट है, फोर्थ पॉइंट है, इसी में लिखो अब सब हेडिंग। प्लीज टेकन बाय डिफेंडेंट। Please taken by defendant. First, lack of knowledge of minority of plaintiff. सबसे पहली प्ली थी जी, मेरे को पता नहीं था कि ये प्लेंटिफ है, ओ ये माइनर है। लिखो, Brahmodatt pleaded in the court. Brahmodatt pleaded in the court that he was not aware. Brahmodatt pleaded in the court that he was not aware. He was not aware. He was not aware about. He was not aware about. He was not aware that plaintiff was a minor. That he was not aware that plaintiff was a minor. Plaintiff was a minor. ठीक है, लिखो, it was proved that his agent Kedarnath Mittal, it was proved that his agent Kedarnath Mittal very well knew about minority of Dharmodas, very well knew about minority of Dharmodas, very well knew about minority of Dharmodas, and applying the principle of agency, agency the court held that agent's knowledge was principal's knowledge. The court held that agent's knowledge was principal's knowledge. Agent's knowledge was principal's knowledge, and hence the plea of Brahmodat was rejected. The plea of Brahmodat was rejected. The plea of Brahmodat was rejected. ठीक है? B. Fraud on part of plaintiff. Fraud on part of plaintiff. Students, are you able to keep up with the pace? Am I going fast by any chance? Please just tell me once. Can you keep up with the pace? Are you okay? Yes, okay. लिखो. Brahmodat pleaded that the plaintiff committed fraud. The plaintiff committed fraud. The plaintiff committed fraud by signing the document. The plaintiff committed fraud by signing the document which stated that he was of age of majority. Which stated that he was of age of majority. Which stated that he was of age of majority. ठीक है? इसी में लिखो, this plea was also rejected by the court. This plea was also rejected by the court. This plea was also rejected by the court on the ground. This plea was also rejected by the court on the ground that a deceit which does not deceive, is no fraud. ये मैं आपको सब पढ़ा चुकी हूँ, ये आप कल को सेक्शन 19 में भी पढ़ोगे. A deceit which does not deceive is no fraud. A deceit which does not deceive is no fraud. Dash. Since Kedarnath Mittal was fully aware about minority of plaintiff. Since Kedarnath Mittal was fully aware of minority of plaintiff. Since Kedarnath Mittal was fully aware of minority of plaintiff, comma, the declaration by plaintiff did not constitute fraud. The declaration by plaintiff did not constitute fraud. The declaration by plaintiff did not constitute fraud. Okay. Third, plea to bind minor by estoppel. Plea to bind minor by estoppel. Echo. The defendant claimed that since the plaintiff had signed a document stating that he was major, since the plaintiff had signed a document stating that he was major, comma, he must now be precluded. Preclude करना मतलब prevent करना. He must now be precluded. From claiming minority as a defense. He must now be precluded from claiming minority as a defense. Basically, ब्रह्मदत्त कह रहा है कि धर्मदास ने डॉक्यूमेंट साइन किया था कि वो माइनर है. अब वो कोर्ट में आके कह रहा है कि मैं मेजर हूं. तो मैंने आपको बताया था एस्टॉपल ऑपोजिट प्लीज लेना अलाउ नहीं करता. ठीक है. क्या बोला है मैंने? ही मस्ट बी प्रिक्लूडेड फ्रॉम क्लेमिंग दैट ही इज अ माइनर. फुल स्टॉप. For this, the defendant supported his argument by the doctrine of estoppel. Supported his argument by the doctrine of estoppel. Supported his argument by the doctrine of estoppel. ठीक है. इसी में लिखो, the plea of estoppel was rejected on the following grounds. The plea of estoppel was rejected on the following grounds. First, estoppel does not apply against the statute. Estoppel does not apply against the statute. Dash. The purpose of doctrine of estoppel is to supplement law. The purpose of doctrine of estoppel is to supplement law and not defeat it. Is to supplement law and not defeat it. And not defeat it. Dash. If minor is precluded from claiming minority, if minor is precluded from claiming minority, if minor is precluded from claiming minority, comma, the transaction related to mortgage with minor, the transaction with mortgage, the transaction related to mortgage with minor, the transaction related to mortgage with minor will become enforceable, will become enforceable dash estoppel will make that lawful which statutes prohibits. Estoppel will make that lawful which the statute prohibits. आपने estoppel लगा दी, आपने माइनर को बोला तुमने कोर्ट में कह सकते माइनॉरिटी क्योंकि तुमने पहले डिक्लेरेशन साइन कर दी थी, तो आपने माइनर को रिलीफ नहीं दिया, तो मतलब मॉर्गेज इन्फोर्स हो रही है. सो एस्टॉपल जो एक टेक्निकल डॉक्ट्राइन है वो लॉ के अगेंस्ट जा रही है. लॉ कह रहा है माइनर के साथ अग्रीमेंट को हमें इन्फोर्सेबल नहीं बनाना, माइनर कॉम्पिटेंट नहीं है, सेक्शन 11 भी कह रहा है, और आप उसको कॉम्पिटेंट बना रहे हो एक डॉक्ट्राइन की हेल्प से, तो वो तो डिफीट हो गई है ना. सेकेंड, estoppel has no application. Estoppel has no application where the truth is known to the other party. Estoppel has no application where the truth is known to the other party. Where the truth is known to the other party. Full stop. Since Kedarnath Mittal knew about minority of Dharmodas Ghosh, since Kedarnath Mittal knew about minority of Dharmodas Ghosh, comma, the plea of estoppel will necessarily fail. The plea of estoppel will necessarily fail. The plea of estoppel will necessarily fail. ठीक है. D, plea for restitution. देखो, the most pressed plea of the defendant was that the ये ना फिफ्थ प्ली है, सॉरी, ठीक है. फोर्थ प्ली पहले लिख, वैसे तो कुछ भी लिख लो फर्क नहीं पड़ता, बट बेटर वुड बी, सॉरी, फोर्थ वुड बी departure from English law unwarranted. लिखो, the defendant took the plea, the defendant took the plea the defendant took the plea that as per English law, minus contract is voidable. As per English law, minus contract is voidable. And there is no rational basis. For departure from settled position. There is no rational basis for departure from settled position. There is no rational basis for departure from settled position to declare it as void agreement. To declare it as a void agreement. Okay, देखो. The court reasoned that minors are accorded special protection in law. Minors are accorded special protection in law. Minors are accorded special protection in law on the basis of parens patriae. On the basis of parens patriae. State parent होती है, state protect करती है. On the basis of parens patriae. इसी में लिखो, due to insufficient cultivation of mind, comma, minors are to be protected. Not only from exploitation by others. Minors are to be protected not only from exploitation by others. But also their own poor judgment. दूसरों से नहीं बचाना, खुद से भी बचाना है. From their own poor judgment. On this basis, no purpose is served by making the contract voidable. On this basis, no purpose is served by making the contract voidable. No purpose is served by making the contract voidable. And the correct approach would be to make any agreement with minor as void ab initio. The correct approach would be to make any agreement with minor as void ab initio. ठीक है, ई लिखो, ई plea for restitution. देखो, the most pressed plea, of defendant was that the most pressed plea of defendant was that the minor be directed. The most pressed plea of defendant was that the minor be directed to return rupees 10,500. Minor be directed to return rupees 10,500 which was advanced to him by way of loan. Rupees 10,500 which was advanced to him by way of loan. इसी में लिखो, the court rejected the plea on the following three grounds. The court rejected the plea on the following three grounds. The court rejected the plea on the following three grounds. Okay. First, no restitution under Section 64 Indian Contract Act. No restitution under Section 64 Indian Contract Act, since it applies only to voidable contracts. No restitution, ये सब मैंने समझा रखा है. No restitution under Section 64 Indian Contract Act, since it applies only to voidable contracts. Next, no restitution under Section 65 Indian Contract Act, since it does not apply to void agreements. No restitution under Section 65 Indian Contract Act, since it does not apply to void agreements. Since it does not apply to void agreements. Since it does not apply to void agreements. Last, no restitution under Section 41 Specific Relief Act 1877. मैंने सब बता रखा है, पहले पुराना Specific Relief Act था. No restitution under Section 41 Specific Relief Act 1877, since it is available on equitable basis. Since it is available on equitable basis. since it is available on equitable basis, and the defendant had no case for equity as per court. And the defendant had no case for equity. The defendant had no case for equity as per court. The defendant had no case for equity as per court. ठीक है? Last F, last plea for equity. Plea for equity. Wait. Plea for equity. देखो. The defendant cried in the court. The defendant cried in the court that it would be highly unjustified, that it would be highly unjustified, it would be highly unjustified if the court allows cancellation of mortgage, if the court allows cancellation of mortgage and also allows minor to retain rupees 10,500 of loan. If the court allows cancellation of mortgage and also allows the minor to retain rupees 10,500 of loan. He thus pleaded for return of loan money. He thus pleaded for return of loan amount. He thus pleaded for return of loan amount on the ground of equity. On the ground of equity. ठीक है, लिखो. Rejecting the plea, the court reiterated the classical principle of law. The court reiterated the classical principle of law dash one who seeks equity must do equity. Reiterated the classical principle of law that one who seeks equity must do equity. देखो, the court held that the defendant's agent very well knew that the plaintiff was a minor The defendant's agent very well knew that plaintiff was a minor, and yet he entered into a contract, with him. He entered into a contract with him to grab his property, dash, this lust and greed does not deserve equity. This lust and greed does not deserve equity. Dash, one must come to the court with clean hands. One must come to the court with clean hands. कोर्ट ने बोला आप तो इक्विटी की बात करते हुए अच्छे ही नहीं लगते. ठीक है. Okay. This is all about the Mori Bibi case, including all the facts and all the pleas and reply of the court. Please tell me, are you all clear about this case in totality? Then we'll move to next part. Everybody's good? Okay. The fifth topic would be restitution in case of minor. मैंने आपको बहुत अच्छे से बताया था, जनरल रूल होता है, रेस्टिट्यूशन नहीं होता. आपकी गलती है, आपने क्यों कॉन्ट्रैक्ट किया. हाँ, माइनर ने फ्रॉड किया था तो कॉन्ट्रैक्ट वॉइड होगा, लेकिन रेस्टिट्यूशन हो जाएगा. बट फिर कैश के केस में रेस्टिट्यूशन नहीं होता था, जिसमें मैंने आपको लेस्ली वर्सेस शील और अयोध्या प्रसाद, खान गोल, ये सारी चीज़ें बताई थी. तो अब उसी को हम एक बार लिख लेते हैं, मैंने सब बता रखा है. सो रेस्टिट्यूशन इन केस ऑफ माइनर, इसमें आप लिखो, इसको 2 में डिवाइड करो. जनरल रूल एंड एक्सेप्शन. ठीक है. जनरल रूल में लिखो, एक सेकेंड, मैं ना चाहती हूँ आप एक सेकेंड वापस जाओ, जस्ट गो बैक टू थर्ड पॉइंट में जाओ, जो आपने लिखा था ना, माइनर्स ऑफ नेचर ऑफ माइनर्स एग्रीमेंट वॉइड एब इनिशियो, उसमें ब्रैकेट में लिख लो वॉइड इवन इन केस ऑफ फ्रॉड और मिसरिप्रेजेंटेशन बाय माइनर. उसमें नोट लिख लो, फ्रॉड void even in case of fraud or misrepresentation by minor. ये मैंने बता रखा है, चाहे माइनर अपनी एज गलत बताता है तो भी अग्रीमेंट तो void रहता है. I have already told you this point. Void even in case of fraud or misrepresentation by माइनर। ठीक है, और अब वापस रेस्टिट्यूशन पे आ जाओ। रेस्टिट्यूशन इन केस ऑफ माइनर, जनरल रूल लिखो, नॉट अलाउड, नॉट अलाउड। उसके नीचे आरो बना के लिखो, इन केस ऑफ अग्रीमेंट विद माइनर, in case of agreement with minor, in case of agreement with minor, comma, in case of agreement with minor, there will be no restitution, there will be no restitution, there will be no restitution of any benefit given under the agreement. There will be no restitution of any benefit given under the agreement. There will be no restitution of any benefit given under the agreement. ठीक है? Exception, exception. In case of fraud by minor, in case of fraud by minor, comma, though the transaction is void, though the transaction is void, comma, restitution will be allowed, restitution will be allowed, and the minor will be directed to return, and the minor will be directed to return the benefits which he had obtained by fraudulent means. The minor will be directed to return the benefits which he had obtained by fraudulent means. The minor will be directed to return the benefits which he had obtained by fraudulent means. ये मैंने आपको पढ़ा रखा है, ठीक है? इसी में आप एक हेडिंग बनाओ, सब हेडिंग, नॉट द नेक्स्ट पॉइंट. Restitution in case of cash. हम बात कर रहे हैं जब माइनर ने फ्रॉड करा है, बट कैश का रेस्टिट्यूशन होना है. सब मैंने आपको पढ़ा रखा है. तो इसमें लिखो ए, लेस्ली वर्सेस शील. Restitution will not be allowed in case of cash. और इसी में क्लासिकल लाइन दी थी, restitution stops where repayment begins. Restitution stops where repayment begins. ये मैंने आपको सब बता रखा है. ये लेस्ली वर्सेस शील में था, कैश में रेस्टिट्यूशन नहीं होगी. मोरी बीबी वर्सेस धर्मदास घोष. Leslie versus Shield was followed. No restitution in कैश अगर माइनर को आपने पैसे दिए थे, उसने आपको बेवकूफ बनाया था, आपने उसको पैसे दिए थे, वो पैसे नहीं वापस करेगा, क्योंकि अगर आप पैसे वापस कराने लग गए तो एक तरह से आप कॉन्ट्रैक्ट एनफोर्स कराने लग गए। यार इस बात की तो कोई सेंस नहीं बनती, मैंने पहले भी बताया था। देन खान गुल वर्सेस लाखा सिंह। इसमें बोला था restitution will be allowed in case of cash also. फिर अयोध्या प्रसाद वर्सेस चंदन लाल। Angul case was overruled. No restitution in case of cash. And finally, section 33 of Specific Relief Act 1963, जो हमारा अभी चल रहा है ना, वो वाला लो। Restitution allowed in case of fraud by minor, restitution allowed even in case of cash. ये रेस्टिट्यूशन पे कंप्लीट पिक्चर है। आपके मैसेजेस आ रहे हैं, मैम हाथ थक गए हैं, मैम दिस इज ऑल। कोई बात नहीं, आज हम इतना लिख लेंगे। जो बाकी टॉपिक्स बचे हैं ना, नेसेसिटीज थोड़े से ही बचे हैं, नेसेसिटीज, बेनिफिशियल कॉन्ट्रैक्ट और रैटिफिकेशन बाय माइनर, और माइनर एजेंट बन सकता है कि नहीं, पार्टनर बन सकता है कि नहीं, मैंने सब बता रखा है। वो मैं आपको नेक्स्ट क्लास में लिखवा के देन वील कम टू द टॉपिक ऑफ अनसाउंड माइंड। कॉम्पिटेंसी की जो दो और लेग्स हैं, अनसाउंड माइंड एंड डिस्क्वालिफिकेशन। ठीक है, तो आज के लिए इतना ही। आई कैन अंडरस्टैंड, प्लीज इसको रिवाइज करना और नेक्स्ट क्लास में हम इसको पूरा करके बाकी दोनों पार्ट्स ऑफ कॉम्पिटेंसी भी कंप्लीट कर लेंगे।